Good morning, everyone, and welcome. My name is Alisa Sladzinska, and I work for the City of Chicago, Department of Business Affairs and Consumer Protection, BACP. Welcome to the BACP Business Education Workshop Webinar Series. We have adapted our regular business education workshops at City Hall into these webinars until further notice. On behalf of our Commissioner, Rosa Escarino, I want to inform you that business licenses can be processed online where applicable by visiting chicagobusinessdirect.org. If you are part of the BACP Entrepreneur Certificate Program, you can get credit for joining this webinar by sending an email to bacpoutreach@cityofchicago.org. If you want to learn about the program, please visit chicago.gov/businesseducation. And as I go through the different emails and websites, please note I will post them in the chat box so you'll be able to reference them there. And to help guide your business and employees during Chicago's reopening process, please visit chicago.gov/reopening. Also, BACP and the City of Chicago's Office of Emergency Management and Communications created Shy Biz Emergency Alerts. You can opt in to receive targeted emergency alerts for the business community. If you are interested, please visit chicago.gov/shy-biz-alerts. And we encourage attendees to ask questions. Please use the chat box and send your questions to all panelists. There will be a question and answer session at the end of the presentation. And today's webinar is choosing the right legal entity for your small business. Our presenter today is Stefania Alessi. Welcome, Stefania.
Hi, hello everyone.
Hello, you're ready to begin.
Perfect. So good morning everyone and welcome to the webinar. My name is Stefania Alessi. I'm a corporate associate the Corporate and Securities Group at Mayor Brown here in Chicago. Also on the line is Paul Crimmins, is a corporate partner in the Chicago office and the head of the Corporate and Securities Group in the Mayor Brown Chicago office. So the goal of the webinar today is to discuss the basic forms of business structures that are available to small entrepreneurs and also learn the importance of the differences between each legal structure. First of all, I want to congratulate you because if you're attending this webinar, I imagine it's because you're either considering starting your business or you've already started it and you want to know more. So you're taking a big step, and we hope that this will help you structure your business the way that it works for you. So these are some of the legal entities that we are going to talk about today. Sole proprietorship, different kinds of partnerships, limited liability companies, corporations, and then if you're interested in social enterprise, L3Cs or benefit corporations. So straight out of the bat, let me tell you that there is no right or wrong answer as to which type of entity you should choose, and there is not one answer. It really depends on what you want from your business and how you want to structure it. For example, some of the key considerations will be personal liability. That is a huge concern for entrepreneurs, and several types of entities allow to separate ownership from management and thus shield the business owner from suits that could be brought against the business. Also, just as you do not want to be held personally liable for a lawsuit against your business, it's also essential to shield your personal assets from potential business liability. And we'll see how you can do that. Other types of considerations are how do you want the decision-making process to work in your business? What kind of ongoing administration requirements are you willing to take on? What costs? And also, you need to consider if you want your business to outlive you. So if you want to pass it on your children or collaborators, there are certain types of entities that die with the owner. So it's crucial for the owner to decide how and whether the business will live on. The first type of entity we're going to talk about is not an entity, it's more of a business structure. That's sole proprietorship. A sole proprietor is simply the name that is given to someone who starts engaging in a business without setting up a formal corporate structure. The classic example is the lemonade stand. We don't advise small entrepreneurs to adopt this business structure, as the owner is exposed to unlimited personal liabilities, even if the liability arises from the business. So, for example, say in your lemonade stand, if it turns out that the lemons were not good and some people get sick and they sue you, you will be personally responsible, even though that's a fact of the business, and the creditor will be able to attack your personal assets if the assets of the business are not enough to cover the loss. On the other hand, to start a sole proprietorship, you need to do absolutely nothing. There's no filing requirements. There's no reporting requirements. You will only need to register your business name, as we'll see in a minute. In terms of taxation structure, the sole proprietorship has a structure as a personal taxation form, meaning that all the profits and losses of the business will pass through the owners. So you as the owner would need to report this information on your personal tax return. General partnerships are business arrangements where two or more people are owners of the business and do business together. So thinking about the lemonade stand example, if you and your neighbors get together and start running the lemonade stand together, you're in a general partnership. There's no formal agreement required. There's no filings required. And much like a sole proprietorship, you and the other person will be personally and unlimitedly liable for any losses and any lawsuits brought against the business. If you do not file anything, the general partnership is the default form of your business. We always recommend, if you choose this type of business structure, to have a partnership agreement. That is an agreement among the partners that governs internal relations. So that will give you the possibility to decide which partner has the authority to do what and how your business is run. Like the sole proprietorship, the tax structure and the tax treatment for general partnership is the pass-through taxation. So any losses or gains or revenues of the business, you will have to declare them in your personal income. To create a general partnership, you just need to choose a partnership name, file an assumed business name certificate, draft and sign a partnership agreement. As I mentioned, that's not necessary, but we strongly recommend you do that. And then obtain any licenses and permits that depends on the type of industry you're going to operate in, and also on the state and the county. And you need to obtain an employer identification number, or IEN. So even though it's your tax return, you will still need to obtain a number. An assumed name is a name that is issued to an entity that uses a name other than the names of the individuals who own or operate the business. So if your lemonade stand, if your name is John Johnson and the name of your stand is John Johnson PC, you won't have to file for an assumed name. But if your name, the name of your business is John Lemonade, then you will have to file. Under state law, there are three classes of businesses that are required to register for assumed names with the local county clerk's office. And these are sole proprietorships, general partnerships, and professional services corporations. Businesses that do not require to register are limited partnerships, limited liability partnerships, and limited liability companies, all of which we'll talk about in a second. The reason why you don't need to register for these kinds of business is because you will anyway have to file other documents with the Secretary of State. Limited partnerships have both general partners and limited partners. A limited partner is one who does not have unlimited liability for the debt of the partnership. So the most a limited partner can lose in his investment in the business is the amount that is actually invested in the business. The trade-off is that that limited partner will lack management control. The general partner, much like in a general partnership, is unlimitedly liable for the debt of the business, but on the other hand, it also has the right to control and manage the business. So there's a trade-off between the management control you get and the exposure to liability. This type of entity is used a lot in real estate. For real estate companies that only want to call in investors that are only going to put the capital, whereas the general partner is the one that is actually going to manage the company. Again, personal taxation is the tax structure for this type of business. So you will have to pay taxes for the business on your personal income and report those in your personal income. To form a limited partnership, there's a limited amount of steps that you need to follow. First, you need to file a certificate of limited partnership. In Illinois, the fee is $150. If you decide to form your entity in another state like Delaware, the fee is $90. You also need to choose a registered agent within the state. A registered agent is a person or entity that is appointed to accept service of process and official mail on your business's behalf. It's, in short, a due process requirement. A claim, a lawsuit against your business cannot proceed without you. Therefore, you need to appoint someone that can be you or another individual to accept these notifications. You can also appoint a service company. There are companies that provide registered agent services, and the cost is about $360 a year. Some businesses decide to incur this cost because it's less paperwork for you. The registered agent services will have a system in place to track and notify you when reports are due, for example, or they will keep an eye on your business compliance with the laws of the state, so you don't have to worry about it. Another reason why some people prefer to use a registered agent service company is privacy. So when you register your business, you will need to provide the address of the registered agent. So if you decide you're going to be the registered agent, you probably need to disclose your personal address, meaning that if there's anybody who wants to officially contact your business, they will know your home address. So that's the reason why for some people this is a concern, others don't care. You will need a partnership agreement that regulates the functioning and the management of the business, and again, obtain any licenses you need and obtain an EIN. Limited liability partnerships are a hybrid between a company, a corporation, and a partnership. So similarly to limited partnerships, they have limited partners. The difference is that a limited partnership needs to have at least one general partner. Limited liability partnerships do not have general partners. They're all limited partners. And this is because a limited liability partnership is a separate legal entity from its partners. So all the partners have limited liability, and the limited liability partnership will be liable to the full extent of its assets for any debt or claim. This entity is also taxed like a limited partnership. It's passed through taxation, and the filing requirements are exactly the same as a limited partnership, plus you will need to file a statement of qualification. The fee is about $100 per partner in Illinois. One of the type of entities that is extremely popular among small business owners is a limited liability company, or LLC. The LLC is also a hybrid that combines the flexibility of a partnership with the asset protection of a corporation. So much like a limited liability partnership, the LLC is a separate entity from its owners, so it has its own rights, responsibilities, and liabilities. This means that an LLC can file a lawsuit or can be sued in its own name. It can buy, own, and use real estate. It can enter into contracts, etc. Because the LLC is a separate entity, the owners of the company have limited liability. The owners of an LLC, by the way, are called members, and they have limited liability. This is one of the most important benefits, as that means that the LLC members will only lose, in the worst case scenario, their investment in the company. One of the main points in limited liability companies is that members have freedom and many options for their management structure. By state law, the control, the management of an LLC rests with its members, so the owners. But if the owners want, they can split ownership from management and have a manager, one or more managers, manage the LLC. So the members will be the owners, and the managers will have the management of the company. The managers don't have to be members; they can be third persons that are hired by the LLC, and that's why we usually distinguish LLC is in member managed or manager managed. That basically means member managed, the owners are the ones doing the management. Manager managed, there are managers doing the management, and the members are just owners. One other positive feature of the LLC is its perpetual existence. So unless the articles of organization of the LLC specify differently, an LLC will have perpetual existence. This means that the owner can change without triggering the dissolution of the company. That's not the same for a partnership, for example, for a general partnership. The governance is highly flexible. The members will enter into LLC operating agreement or just operating agreement. That's a contract among the members that will define how the company is run, how the interest in the LLC, the membership interests are divided, how the losses are split among the members, etc. One important feature about the LLC is that the managers can decide how they want to allocate income, loss, or tax items. So, for example, even if a member owns 10% of an LLC, the operating agreement can establish that that member will get 50% of the income and bear 10% of the losses. So it's completely up to the owner deciding how to split income, losses, and tax items. LLCs imply slightly higher cost of formation. So compared to limited partnerships, for example, you will need to file articles of organization or certificate of formation, either name indicates the same document, with the Secretary of State. The members will need to enter into an operating agreement and, if necessary, any organizational consent. An example is after they form the LLP, the members will have a consent approving the appointment of managers, for example, if they choose to have managers. There are some ongoing administrative requirements with the LLC. You don't have these requirements for limited partnerships, but it's generally less onerous than for a corporation. You will need to do some record keeping for the LLC. Corporations are a separate legal entity, so they're much like a living and breathing person. They are made up of shares that are owned by individuals called the shareholders. And just like for the LLCs in corporations, the shareholders' personal assets will be shielded from any liability of the business. Corporation, to form for a corporation, you must file so-called articles of incorporation with the Secretary of State. All these initial filings, by the way, are available in the Secretary of State's website. So they're very easy to find, and they're just forms that you need to fill out. Once you form your corporation, you will need bylaws. Those are the laws that govern the functioning of your corporation. So it's a document that just says how the corporation works. Then you will need to have organizational meetings that approve, for example, the bylaws, approve the appointment of the board of directors, and get your business started. Also, the corporation will need to issue stock certificates to the initial owners, as each shareholder will have a certificate stating how many shares they own in the corporation. There are a lot more formal reporting requirements related to corporations that include at least an annual report to be filed with the Secretary of State. That's a report that states, for example, the name of the corporation, the state where it's incorporated, the kind of business they do, and this is usually used by the state to assess how much tax the corporation needs to pay. You need to have annual meetings, at least one annual shareholders meeting, and also only the board of directors and the officers will have the authority to act on behalf of the company. So there is again a split between the owners, who are the shareholders, and the management of the corporation in this case, and the management is only for the board of directors and the officers. One of the potential disadvantages of the corporations are the tax structure and the tax treatment. So corporations are subject to what the so-called double taxation. That means that the corporation must file a federal tax return and pay federal taxes on any income that it earns, and any profit that is distributed to the shareholders will be taxed again as personal income. You can avoid this by electing to be taxed as what is called an S-corporation or S-Corp. S-Corps have pass-through taxation. You just need to file a form with the Internal Revenue Service. But there are some differences between S-corporations and double taxation corporations that are called C-corporations. The main difference is not only tax treatment, so C-corps have double taxation, S-corps have pass-through taxation like an LLC, but also S-corporations have limits on the types of shares that they can issue. So, for example, a C-corporation is able to issue many different kinds of shares. They're usually called Class A, Class B, Class C, and so on. Each class of shares will have different rights. So you can decide that the holders of Class A shares have a right to vote, whereas the owners of a Class B shares don't. This way you can arrange the business the way you want to run it. When it comes to S-Corps, they can only issue one type of share. So you won't have that flexibility. There are also some requirements that S corporations need to have, and we'll see those in a minute, and that C corporations don't necessarily have. Benefits corporations are traditional corporations, but have modified obligations that commit to creating a general public benefit. From the top of my head, a famous benefit corporation is Patagonia, for example. So the benefit corporation status provides a benefit corporation the right to balance financial and non-financial interests when making decisions. Regular C-Corp or S-Corp, in a regular C-Corp or S-Corp, the board of directors has a duty to maximize the profit for the shareholders. Benefit corporations can balance this duty with whatever non-financial interests they're pursuing, whether it's environmental, social, etc. Other than that, benefit corporations are exactly the same as any C-Corp or S-Corp. They follow the same corporate formalities. If you decide to choose a benefit corporation form, you need to consider whether the company is able to accomplish the purpose that it has in terms of both being profitable and accomplish the non-financial interests, obviously. So we said that S-Corp are corporations that are taxed with a pass-through structure, and in that way they're very similar to LLCs. One thing you should know is that LLCs, as part of their flexibility feature, they are generally pass-through entities, but you can also choose to have an LLC taxed as a corporation, so with a double taxation. And that might be something you want to consider, for example, if you want to keep a lot of the profit in the LLC because you want to reinvest it. Maybe it would be more profitable to use a double structure, a double taxation. We always recommend you consult with your accountant or with a tax expert before you make any decisions, but I just wanted to put it out there for you to consider. It's worth to do a quick comparison of S-Corps and LLCs because even though they can potentially have the same tax structure, the S-Corps have some limits that I was mentioning before. For example, the foreign shareholders are not allowed in S corporations. So if you're thinking of bringing in foreign investors, you should use an LLC. There's a limit of the number of shareholders that an S corp can have. The LLC does not have any limits on the number of members. So an S corp can have maximum 100 shareholders. Therefore, if you're thinking of getting funding through, for example, crowdfunding, you need to consider that you will have a limit in the number of investors if you choose an S corporation versus an LLC. And also, as mentioned before, LLCs offer a lot of flexibility in terms of distributions of profits and losses, whereas in S corporations and corporations generally, profits and losses are distributed solely based on the percentage ownership. So if a shareholder owns 10% of the corporation, he or she will get 10% of the profits and bear 10% of the loss. So you may want to consider an S corp if you want to have earnings distributed proportionately to the capital contributions, or if you are okay with stricter formal reporting requirements that corporations generally have. On the other hand, an LLC might be a better choice if you want maximum flexibility in running your company, if you want to allocate profits and losses upon criteria other than ownership percentage, if you are thinking of getting or having a large number of investors, and if you prefer to avoid meeting requirements that are imposed on corporation and the formalities that corporations follow. A quick mention on low-profit LLCs or LCCs. They are LLCs, but they are slightly different in because the owners actively participate in the management and don't face personal liability. So there are private organizations that are for-profit, they're not non-profit, but the owners conduct business so that they can help a certain cause. So in essence, LLPs operate better to better social welfare in some way. A quick word on where to form. So there are some advantages. So Delaware, the state of Delaware, is one of the preferred jurisdictions in which to form a business because it offers multiple benefits. The Delaware Court of Chancery has a well-established case law for business. As an example, directors in a corporation have certain duties, namely a duty of loyalty and duty of care, but the law doesn't necessarily say what that is. The Delaware courts have a better established case law than other states in determining what these are. So, what these duties are. So, it offers more certainty to businesses. Delaware statutes are generally more business friendly, and there are limited disclosure requirements that are imposed on Delaware entities versus entities formed in other states. Generally, although this is changing, outside investors like investment banks, venture capitals, they prefer to invest in companies formed in Delaware because of these factors that I just mentioned. However, you should consider this because there are also disadvantages in forming in Delaware. If you do not intend to be physically located in Delaware, you will, and to operate your business there, you will have additional costs and obligations. So if you want to form a corporation in Delaware but operate your business in Illinois, you will have reporting requirements both in Illinois and in Delaware. You will need to file and pay for to register to do business in Illinois, and you will have to appoint a registered agent in Delaware and Illinois. So those will be additional costs. Also, in terms of LLPs, Delaware imposes a tax on LLPs. Other states don't necessarily do that. If you already have a business and you already chosen an entity, and maybe with this, after this webinar, you decide that that's not the form that is good for you and you want to change, you definitely can. You just need to be mindful of what you are now. If you're an LLC, just consider what are the benefits and the disadvantages of having entity and how much corporate requirements can come. So if you want to convert an LLC to a corporation, you can do that. Just be mindful of the additional formal requirements you will have. Consider any tax liability you have, and how willing you are to take on more, or if you want to return. Are you considering bringing in on investors, other owners? Some entity structures are better for that. And also, as mentioned at the beginning, what is your succession plan? Are you okay with the business dying when you die, or do you want to pass it on to someone else? So these are all elements you should consider. This is just a quick recap of some of the entities we've seen to give you an overview of the differences between the various types of limited partnership, LLCs, and corporations. Some useful sources for you to gather more information are, as Elisa was saying before, the City of Chicago Small Business Resources is a great tool. They help with startups, licenses, zoning. Of course, at the moment, there's no in-person business hours, but you can call the number here on the slide. The Illinois State Bar Association has useful guides for organizing domestic corporations and LLCs. And they also have information about the fees to pay for filing forms, and they have sample forms. Another website that I would recommend is the Illinois Secretary of State. You can download any form, for example, of certificate of limited partnership, of certificate of formation of an LLC. You can find all those online. The Chicago Lawyers Committee for Civil Rights offer pro bono legal clinics and transactional assistance pro bono. Mayor Brown, my firm, we do a lot of work with them. They're great. The Justice Entrepreneur Project, they're private attorneys with flexible rates. So you definitely have tools at your disposal. Use them if you want. And I think, Elisa, if that's okay with you, we can open to questions.
Absolutely. Thank you so much, Stefania, for that overview. I hope it was very helpful to our attendees. And I just want to mention that this webinar is being recorded and will be available on our YouTube channel, which is youtube.com/Chicago BACP. That link is posted in the chat box, so you could reference it there. And now we are going to open it up to questions. I see several coming in. If you do have a question, please send it in the chat box to all panelists, and we will do our best to answer it. So first question is, in what instances would you suggest using a sole proprietorship?
I wouldn't, ever. I would say in anything bigger than a lemonade stand, get some protection and have a proper corporate structure in place. A sole proprietorship will expose you to unlimited losses should anything go bad.
Thank you. Next question. Are there any issues with filing in Delaware as opposed to Illinois?
There's not necessarily issues. It depends. I've mentioned it depends on what you want to do. Delaware is the jurisdiction that is normally chosen by, that is more often chosen, I should say, by business entities because it's because judges in that state are basically corporate specialists. They do a lot of corporate cases, so it will give you more certainty should anything end up in court. And also because the corporate statutes there are generally more business friendly. However, if you're planning to operate only in Illinois, you should consider whether that's worth, because Illinois statute is fine. It's not just that it's a bad statute versus a Delaware law statute. And you will have additional costs if your entity is formed in Delaware but you're operating only in Illinois. You have to register your company to do business in Illinois, because under Illinois law, your state a corporation. Your corporation will be treated as a foreign corporation. So you need to register for business. You have to appoint a registered agent both in Delaware and in Illinois. And the requisite for a registered agent is to be domiciled in that state. So say you want to appoint yourself as registered agent and save some money, you still need someone who is domiciled in Delaware to be the registered agent for your company in Delaware.
Okay. Can a foreign investor own shares in an S-Corp with the ESBT? What is ESBT? This person did not mention it. If that person could just break down that.
Yeah, electing small business trust. No, the requirement for an S corporation is that it cannot have any foreign investors. So no foreign investors could be admitted. you would have to do either a C corporation, but then you have the double taxation, or an LLC.
This is a good question. Can you choose LLC and then change to corporation or vice versa?
Yes. You can convert your entity into anything you want. You just need to follow certain steps. And you can convert an LLC to a corporation. I mean, we can get into details of how to do it, but I'm not sure how much time we have, but yes, you certainly can. And there's a lot of associations that offer pro bono counseling, and they can do that for you.
Question is there a general recommendation for first-time entrepreneurs? This person specifically is starting an HR consulting company.
It depends on what you want. I know it's the answer that lawyers always give is like, it depends, but it really depends on what you want to do. When I advise small entrepreneurs, usually on pro bono cases, the choice is up to the business owner. But generally, as a first-time entrepreneur, you should consider the LLC because it gives you freedom. You can decide how you want to structure your business, and you also have limited exposure to the liabilities for your business. So should anything go wrong, the most you can lose is the amount you invested. No one will be able to attack your personal assets.
Great. Question is, if you start an LLC in Illinois, but then move the business to another state, do I need to reapply or transfer to the state I relocated to?
So, as an example, say you started an LLC in Illinois, but then you moved your business to Florida. You will have to register your LLC to do business in Florida, because under Florida law, your LLC will be considered a foreign entity. So you need to pay whatever registration fees Florida has. And then, so you don't really need to reapply. But if at some point you realize that you don't want to do business in Illinois at all, and you only want to do business in Florida, the solution will be to convert your LLC from an Illinois LLC to a Florida LLC. And you just need to file some forms and pay the fee that is necessary. You should have an attorney look into this, just because it's an administrative process, so you just need to know what to do.
Great. A good question is, what entity choices are there for nonprofit?
The same as for profit. So you can have a limited partnership, you can have an LLC. Recently, we formed a corporation for a nonprofit. So the initial steps are exactly the same. So the only difference is that if you are a nonprofit, as soon as you form the entity, you need to file a form, and lawyers can do that for you. You can need to file a form with the IRS that says, I'm a nonprofit, this is what my goal is, and I want to be exempted from taxation. That's how you do it. But the formation steps and the types of entities are exactly the same.
Okay. Regarding the liability shield of an LLC, how effective is the liability protection if the LLC is thinly capitalized and carries no insurance?
That's a good question. So the liability shield protects the members, so the owners of the LLC, from any liability incurred by the business. Maybe now we'll get a bit past the scope of this of this webinar, but there is a thing that is called piercing the corporate veil. So if, say, the LLC is sued and you end up in court, you need to be careful not to operate this business as if the court thinks that, yes, you have a business, but you just used it for the shield, the business wasn't really doing anything, it was you all along, then they might decide to pierce the corporate veil and attack your personal assets. So there are several cases in jurisprudence, but these were kind of excessive cases. Like the owners would do business, would just use the entity as a shield. The entity wouldn't really do anything. It was the owner all along. And in those cases, court said we do not allow this.
You talked about this during your presentation, but can you mention briefly what are the differences between LLC and S-Corp?
So the difference, LLCs and S-Corps are both pass-through entities, although remember that LLCs can also elect to be taxed as a C-Corp, so they can choose double taxation if they want to. The main differences are S-Corps have stricter requirements when it comes to number of shareholders and where the shareholders are from. So no foreign shareholders are allowed for S-Corps, but you can have foreign shareholders in LLC. S-Corps can only have 100 shareholders, tops. LLCs can have as many members as you want. Another difference that you should consider is the fact that LLCs have that flexibility component that allows you to have different classes of membership interests with different rights, and you can also decide to allocate profits and losses the way you want. S-Corps can only issue one class of shares. So imagine even if you decide to have 100 investors, S-Corps, you will have 100 shareholders with the same rights. So imagine, because it's a corporation, you will need to have annual shareholders meetings. Consider having 100 shareholders that can all vote on something. It might slow down your decision process. So yeah, I would say these are the main differences.
Okay. And just really quickly, once again, this webinar is being recorded and will be available on our YouTube channel, which is youtube.com/Chicago BACP. We will not be sending out the PowerPoint presentation, but obviously the video will have the entire PowerPoint present, so you'll be able to review slides that way. And we do have several questions coming up about Delaware. First question is, what does it mean to be operating in Delaware? Do I need to have a brick and mortar there?
That's another good question. To operate in Delaware means doing business there. And doing business is not a definition that is set in stone, but generally what courts have considered doing business is actually dealing with something. So if you own a storage room in Delaware, that's not doing business. But if you start selling from that storage room, then that is considered doing business. So to answer metaphor with metaphor, you can have a brick and mortar there, and if you don't use it, that's not doing business. If you start using it and then sell the product, then that is doing business.
Question about Delaware. Is there an advantage for a nonprofit to file in Delaware?
There are exactly the same advantages that you will get for for-profit corporations. So if you think about it, a nonprofit is just a regular entity but the difference is the goal that it pursues and the fact that it's exempted from federal tax. So you will get the same advantages as a for-profit corporation, meaning there is a well-established jurisprudence. The statutes are generally more business-friendly.
And just know we do have a lot of questions coming in, and we are trying to go through all of them. So just be patient. We are working on going through all the questions.
Oh, yeah, for sure.
Next question is, this person has been using their own social security number in accepting payments and paying taxes, even though they're already contracted with a few organizations. They do carry liability insurance, but feel like an LLC would be more beneficial. Does that make sense?
I would talk to an accountant or a tax expert on this. Unfortunately, I do corporate and securities. I do mergers and acquisitions. So although I do see tax issues, I wouldn't be confident giving any tax advice. So yeah, my recommendation is to talk to an accountant, or there's several pro bono services. Our firm offers pro bono services for tax as well. So definitely talk to an expert. You don't want tax advice from me.
Mm-hmm. We often say entrepreneurs should have the dream team of an attorney, an accountant, and an insurance agent. So yes. If you're an entrepreneur, those three are your guide.
Yes.
Next question is, if you register in Illinois, can you operate in dual states? And vice versa, can you register your LLC in a different state and operate in Illinois?
Yes, you can. There are, as I mentioned, administrative requirements to do that. You cannot just start operating in Illinois if your entity is formed in another state. You need to do certain filings and pay the fees, and you will be registering your business as a foreign entity doing business in Illinois. You need to consider also, I just want to underline it, that once you start operating in a state that is different from the state you incorporated or formed your entity, you need to be mindful of what state law requirements that state has. So Illinois might ask you to file a report, or you may need to pay taxes in both states or more, depending where you're operating. So again, having a tax person or an attorney assisting you in this is probably the best advice I can give you.
And this is industry specific, but is it recommended to change rental properties to LLC?
I'm not sure I understand this question.
It could possibly mean that this person has several rental properties under their name. Should they be put into an LLC, or maybe to start a company for rental properties? Yes,
I would say so. If this person who asked the question is the sole owner of the business, they haven't filed anything, they're just renting out properties, you're operating in sole proprietorship. Mm-hmm. So you might want to have an LLC to shield yourself from liability for the business. For example, if an accident happens in one of these rental properties and someone gets hurt, they can come after you and your assets. Whereas if you form an LLC, the creditor or the plaintiff can only come after the assets of the LLC. And also, if at some point you want to have investors come in, you can have an LLC and bring in investors that way.
Can you review S-Corp versus LLC maximum shareholder limit?
Yes, S-Corp 100 maximum, LLC no maximum at all.
Can you change, or do you need to change the registered agent with your LLC as your company grows?
No. No, you don't have to. The registered agent is simply someone that needs to be available and is during business hours and is domiciled in the state, and they can receive any notices you get from either plaintiffs or notifications from the state. So it could be you. If you're domiciled in the state, you can definitely be the registered agent. I know you're over 18 years old, you can definitely be the registered agent. You don't need to change as the company grows. Also, if you appoint a registered agent service company, you can just keep that forever. You don't need to change it.
As a single member LLC, are there liability shields still applicable, and are there any insurance requirements?
So in terms of the insurance requirements, it's I'm not sure. I don't think it's required, but I would have to look into that. It's definitely recommended. There is a liability shield. You need to be careful though, because a sole member LLC is it's kind of a weird entity in terms that you need to be careful to keep yourself separate from the entity per se. Because sole members LLC, someone could make an argument that you're actually using it only for the shield and try to pierce the corporate veil, as we call it. The shield works. Just make sure that you're separating your interest from the operation of the business.
Is there a benefit to form a L3C versus an LLC for a socially driven enterprise?
There's not necessarily a benefit. It's kind of a new kind of entity. L3Cs. There's kind of a cross between a nonprofit, a charitable organization, and a for-profit. The only main difference is the purpose. So L3C's primary purpose is to provide a social benefit rather than to generate economic profit. But other than that, there's not really a difference. You could do either one.
Can an L3C donate grants or funds to people or entities?
Sorry, can you repeat that question?
Sure. Can an L3C donate grants or funds to people or entities? So making donations as an L3C.
They can. At that point, you might as well have a nonprofit, because just remember, an L3C is still a for-profit organization, so you do pay taxes on that. If you want to have your business allow grants, and this sounds more about charitable, like 100% charitable. An L3C is still a for-profit, but it has an ulterior motive, an ulterior social benefit. So an example of an L3C, I think there's one in Chicago, they're like coffee shops that have also the function of bringing together the community. That's what we would consider an L3C. If you're looking to giving out grants, that just looks like 100% beneficial goal to me. So you could just have an LLC and have it register as a nonprofit. We call it a 501c3 from the federal tax rule. It's 501c3. That means that says that certain entities that have certain goals, and only those goals, so they have no for-profit goal at all, they can be exempted from taxation. So I would recommend, if that's your goal, then just go for full nonprofit at this point.
Okay. Is an LLC an option for a sole owner or is this only for partnerships?
No, as I said, the LLCs can be single members, can just have one member. Just be careful not to use the assets of the LLC of your own, because that would be one of the grounds to close the corporate sale.
As a single member LLC, can I set up myself on payroll and are distributions allowed?
So LLCs and also corporations, they distribute any profits to the owners, and those are called distributions for LLCs and dividends for corporations. They can also have employees. So you can definitely be the employee of the LLC and have a salary, and then also pay yourself distribute.
A question is, what is the process to set up an LLC for investing? Can you operate as a single member, and are there any licenses required if you are investing your own money? This person mentioned investing like stocks, real estate, and other businesses. So it almost seems like this person wants to become an investor, if I'm understanding that.
So become an investor in an LLC?
Or do they, as an investor, need an LLC?
Oh, I see. It depends on what you do it for. If you're investing into an entity, it depends. Some people don't want to, for privacy reasons, they do not want to disclose who they are. So they do form an LLC and name it differently than, of course, their own name, and that's how they invest. It depends on, in terms of licenses, that's really contingent upon whatever state requirement the state law says, and for certain activities. So you will need licenses. For example, the main example is sell alcohol. You need a license for that. So it really depends on the business. And I don't really have enough information, sorry.
And I think you already answered this, but can you file as a C-Corp one tax year and file as an S-Corp another tax year?
Yes, but in between you need to convert your C-Corp into an S-Corp. So you can just arbitrarily start filing as an S-Corp. You need to file a certain form with the IRS that says, okay, I'm a C-Corp, now I want to be taxed as an S-Corp. And also you need to meet the requirements of S-Corp. So remember, only one classes of shares, 100 shareholders max, no foreign shareholders. If you don't have those requirements, if you don't meet those requirements, you can be an S-Corp.
And this person's asking a little bit about a timeline. So is it advisable for small businesses to start as an LLC, move to an S-Corp, and finally a C-Corp as the company grows in size?
I'm not sure if it's advisable because I don't really have enough facts to give you an advice, but you can do that. Like you can convert an LLC into an S-Corp, or you can just have the LLC taxed as an S-Corp. Remember, with the LLC, you can choose if you want to be taxed as an S-Corp or C-Corp, or just have regular LLC pass through. That's the default. If you form an LLC, by default, you're pass through. If you decide to be taxed as an S-Corp, that's also pass through, but remember, there's different tax rules that apply, so definitely get an accountant or a tax person to look at it. But also, if an LLC decides to be taxed as an S-Corp, it also needs to meet the S-Corp requirements. So again, classes of interest, only one, 100% top, 100 shareholders top, etc. You can convert. It's easier to convert an S-Corp into a C-Corp. It's just less steps, fewer steps. So you can do that. As your business grows, you can definitely convert it, or you can just be an LLC and just stay an LLC. The LLCs are not necessarily small corporations. There's large companies that are also LLCs. A lot of the private investment funds, they use LLC entities as well. So don't think that LLCs are just for small businesses.
Mm-hmm. Here's a question about having an online business. This person wants to establish an online business, and concerning corporate structure, they don't want to be restricted to a geographical region, but also in compliance with laws. Any idea on what best corporate structure would be for them?
So they want to operate an online business operating several jurisdictions, not just the United States or also abroad. So
they didn't mention abroad, but let's say domestically.
Okay. So whether your business is online or not, the legal requirements are the same. So if you're doing business, if you're selling your products in other states, and knowingly, like, it's not like if you sell your products and you target customers, say in Arizona, you probably have to register your company to do this. Because you will have to pay taxes in that state, and generally you have to comply with the requirements.
Mm-hmm.
So again, it's up to you. You really get corporations, LLCs, anything, limited liability partnership, anything. If you don't want to take on the risk of being exposed with your personal assets for the liabilities of your business, either one of those is fine. And then it really depends on the flexibility you want. If you're bringing in other investors, so these are all considerations that I cannot make for you. I'm just giving you the tools here. This can help you decide what you where you're more comfortable being, knowing that you can choose one, and then if it doesn't work, you can change.
Question is sole proprietorship best for an artist?
Again, I never recommend sole proprietorship. I'm sorry. Even the lemonade stand makes me nervous. You can. I don't know how large your business is, but know that if someone sues you because something is wrong with the painting and they want the money back, and you don't want to give them the money back because for whatever reason, then they can sue you as a person. They won't sue your business.
And we have time only for a couple more questions. First question is going back to the online business, which I think is pretty relevant right now, just as we transitioned more to online. Where is an online business considered to be doing business? Do you have to register in every state if people can buy from anywhere?
That's a good question. I'm not entirely sure. I would need to look into this. I don't want to give an answer and then it turns out it's wrong. I need to think about this. Sorry.
Yeah, absolutely. Question is, if I wanted to change from an LLC to an S-Corp, how many years back can I request for the change?
Oh, so the change can be retroactive?
Mm-hmm.
I don't think it can be retroactive. You will just be an S-Corp from the moment you file on your filings, and the IRS accepts.
Got it. So as we conclude, just a few informational bits. First and foremost, this webinar is being recorded and will be available on our YouTube channel, which is youtube.com/Chicago BACP. Stefania did mention that there are firms that offer pro bono. We at BACP actually partner with the Chicago Lawyers Committee for Civil Rights. They're part of our partners as a nonprofit. They do offer some pro bono services. I will post the link in the chat box. Stefania, do you have any other resources? I believe you mentioned a few in your presentation.
Yes. So
here they are.
Yep, here they are. You'll find them in the slides. And also, I just wanted to underline, we do, like Mayor Brown does a lot of pro bono work with the Chicago Lawyers Committee for Civil Rights. So they're a great resource. And,
absolutely.
And you won't have to pay lawyer fees, which is great if you're starting a business. So yeah, and good luck.
Yeah, absolutely. Thank you so much. So right there on the slide, you see Chicago Lawyers Committee for Civil Rights, which Mayor Brown is a part of. And I did post the link. It is www.clccrul.org. It's posted in the chat box, so it may just be quicker to click on the link to get you to the website. Stefania, thank you so much for spending your Friday morning with us and sharing valuable information as we kick off 2021. Thank you to our attendees. You're on the right path. So thank you, everyone, for joining us. Stefania, thank you again.
Thank you very much, and good luck, everyone.
Thank you. Have a good day, everyone.